Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast, the NJ Laws Tube. In this edition, we look at DWI cases where blood is drawn and how the defense counsel objects to the blood results in a case. Now, number one, the state has to prove that there was probable cause to stop the motorist and also probable cause to take blood samples. Automobiles are within an area of privacy protected by the Fourth Amendment to the United States Constitution. States such as New Jersey have their own constitution that afford greater protection than the U.S. Constitution. Now, the United States Supreme Court has declared that random stops for license and registration checks violate the Fourth Amendment prohibition against unreasonable searches. That was Delaware versus Prowse. So there's no indication that motor vehicle laws are violated or any other laws are violated by the driver. Police may have violated the constitutional rights by arresting a person and bringing them in for a test. Unless, let's say, there's an accident, they have some sort of probable cause. Let's see, to help prepare for the suppression motion, sometimes clients may wish to take photos of the stop or accident location. Clients should also prepare a diagram of the stop accident location. Now, there's many recent cases dealing with search and seizure, and those are set forth on website njlaws.com. So next we're going to go into what the state has to prove if blood is drawn. The prosecutor, the state, has to prove that the blood specimen was obtained in a medically acceptable manner. Let's see, New Jersey actually has a statute for hospital personnel who withdraw the blood to sign for the police. Let's say they have to. There has to be some testimony and proof that the blood was drawn in a medically acceptable manner. Let's see. Now, good defense attorney should file an objection to any lab report, and the U.S. Supreme Court case of Crawford makes any of these lab reports hearsay, and therefore it's not admissible. They have to bring in the chemist. Number three, the state has to prove chain of custody to bring in the chemist to testify to show that what was tested was not tampered with. Let's see. So, chain of custody requires proof. One, testimony by an investigator identifying the item which the investigator police officer took. That there was no there was no tampering with the item while it was in their custody. 3, how it was delivered to the police station for storage. Next, the person who took it out of the locked storage and brought it to the lab for testing. And then testimony by the people at the lab, how it was taken out and brought for testing. So where the item has been submitted for laboratory analysis, proof of chain of custody should ideally include testimony by the person who took the stuff to the lab, proof of the method of reception, storage in the lab, up to the testing. Often the prosecutor can't prove chain of custody. Now, we've probably said number 4, Crawford case. The lab certificate should not be omitted where there's a formal written objection to the lab report, even where there's a statute that says that the lab report goes in. So, for example, New Jersey has a statute 2C:35-19 that says in a drug case, the lab certificate goes in. If there's an objection, it does not go in. Let's see. Other objections we like to include: the certificate is not really legible in that it doesn't describe what tests were done. Certificate fails to establish that the type of analysis that was performed, the subscriber's full training experience, the nature and condition of the equipment used, and the full conclusions. Let's see. Sometimes the state fails to respond to the request for all the notes, and that's the gas chromatograph results are required under New Jersey's case of State versus Weller. The defense should request these. Also, they should request the operator's manual for the instrument that's used, and that was permitted once in the case of State versus Ford. Now, number 5, blood tests are hearsay, and hearsay typically is not admissible. Let's say evidence rule 802, hearsay is not admissible except as provided by other rules. So it's important that an objection be timely made. Let's say The attorney should also argue sometimes that the certificates that are sought to be and documents sought to be introduced were not done by that person, but were done by someone else. Let's see, wasn't part of a official duty. Let's see. Um, we've also looked at, I mentioned the Crawford case, and Crawford's very specific. They're supposed to bring in, it's hearsay, so state should have to bring in the chemist. Now, many states have what's called patient-physician privilege, and prosecutor, district attorney just can't simply send a letter to a hospital saying we want the medical results for someone that was hospitalized after being arrested. New Jersey Statute 2A:84A-22.2 sets forth the patient-physician privilege. Now, there are in New Jersey, for example, there is a Supreme Court case that says the physician-patient privilege does not apply where the police arrested a person, brought the person in, and the blood was drawn only for police purposes, but defense counsel should object anyway. Other objections, the gas chromatograph results were not provided. Number 8, that there's no proper testimony the person was under the influence. Some police departments try to bring in someone called a DRE. They claim it's a drug recognition expert, but there's no federal statute or New Jersey statute that recognizes drug recognition people, evaluators, guessers. What happens is there's something called the Chiefs of Police, International Chiefs of Police, but they're not a governmental entity and have no legal authority to certify someone as a drug recognition person. So that should be objected to. If discovery is not provided, there should be a motion to dismiss or to bar testimony dealing with drugs. And speedy trial is not provided, then a motion should be made to dismiss based upon speedy trial grounds. For other information, visit website njlaws.com or website benotguilty.com. That's benotguilty.com. For other information, call the law office of Kenneth Vercammen, 732-572-0500. Thank you and good luck.